Recently, there have been instances of controversial arrests and the use of force in America and locally. Now, and especially under our own lockdown regulations, does the presumption of innocence still prevail? I'll be using the Lexis Library Advanced Search feature to locate relevant case law that can answer that vexed question. I want to see cases in the All South African Law Reports and the Constitutional Law Reports, so we'll tick these here to filter the results. The search options down here function over the entire judgment text, but for now, I want to limit the results to only the keywords of these cases, since these capture the essence of the case. From the search results, I can see that State versus Bulwana is the most important on this topic. In this case, the accused were found in possession of more than 115 grams of dagga, and the Drugs Trafficking Act said that this meant that they were presumed to be drug dealers, which attracted a heavier sentence. But this placed the onus of proving their innocence on the accused. The Constitutional Court found that this infringed their constitutional right to a fair trial, of which an important part is the presumption of innocence. So the court declared that part of the Trafficking Act to be invalid. This case is just what I wanted. So I can email the case to myself or replace my email with counsel's address or one of my colleagues, or I can download it here. And if I want to see the original PDF as published, I can download it here. I want to research this concept some more. So I'm going to expand the legal citator and look at the case law that this case has cited to see the foundations for their findings. And I see that this case has been applied. So I want to have a look at Rex versus Ndlovu. It's a 1944 appellate division case where the court discussed the onus of proof in murder cases. And the court does a survey of case law and Roman Dutch writers and concludes that the presumption of innocence is part of our law, and that in all criminal cases, it is for the prosecution to prove the guilt of the accused, not for the accused to prove his innocence. Now, I'm interested to see a recent case on this topic. So I'll return to Bulwana using these tabs here, which keep my research open. And I'll expand the judgment treatments. Because the list of later cases is very long, I'm going to filter it to only the green signals, which is later cases that have applied, followed, or approved Bulwana. And I see that the Moyo case is the most recent. So I'm going to open this one. These colored signals really save a lot of time, telling you at a glance whether the case is still good in law or if you need to be cautious and check the appeal history or a later case that is critical of it. The Moyo case is a very interesting application because Mr. Moyo was the community leader of an informal settlement, and he was arrested and charged under the Intimidation Act. A section of the act put the onus on the accused to prove that he had a lawful reason for making the statements in question. The Constitutional Court found that this reverse onus infringed the right to be presumed innocent, the right to remain silent, and his right not to be compelled to give self-incriminating evidence. So the section was declared invalid. Our law is built on many complex layers, and the legal citator is a really efficient tool for legal research, letting you navigate through time and case law to see how legal concepts have developed into the current position. And I'm happy to see that the presumption of innocence, formed in Roman Dutch law and enshrined in our Constitution, still prevails.